Good evening, everyone, and welcome to this Freedom Under Law University of Stellenbosch Department of Journalism Inaugural Lecture. We're very pleased this evening to welcome Dario Milo to kickstart the collaboration between FUL and the University of Stellenbosch Department of Journalism. I'm also very pleased to welcome our Freedom Under Law Chair, Judge Johan Krechler, who's with us this evening. A brief word about the collaboration between FUL and the University of Stellenbosch before I hand over to Herman, who will more fully introduce Dario. As we're all aware, our country faces many challenges, which includes threats to the rule of law. Entrenching the rule of law in any society depends not only on judicial independence and a sound and legitimate judicial appointments process, but also on a public understanding and trust in the legal system. Good legal reporting, in turn, helps us to communicate the workings of the judiciary and judgments of the court to a far broader public. While South Africa has excellent and very many brave journalists, and some of whom are in the room this evening, and who have played a pivotal role in holding the powerful to account, there is a need to cultivate a greater expertise in this field, to provide a platform for practicing journalists to increase their skills, and then to birth a new generation of high-quality legal journalists. Last year, Herman Wasserman, the chair of the Department of Journalism here at the University of Stellenbosch, but when Herman and I had the conversation, he was under the mountain at the other place, but he and I discussed a possible collaboration by way of a series of masterclasses or seminars, which have as their focus training on law and journalism with instruction on the Constitution, legal principles and significant precedents, with the goal of reporting on court matters more incisively. And it's wonderful to see a younger generation of honours journalism students here this evening. And we're hoping that these classes could, as part of a 3-year collaboration, serve as a sounding board for legal journalism, journalists currently practicing, given that theirs is a small and niche field and often not well understood by editors. And I'm grateful to Herman and also to MC Ferreira, who's here tonight from the Mail and Guardian, for those initial conversations. This public lecture is hosted jointly by our two organizations, and the start of this collaboration we hope will contribute positively, not only to bettering the standard of public discourse on legal matters, but to ensure that the way in which the judiciary is covered in the media adds to ordinary citizens' understanding of the legal system, which in turn enhances its legitimacy and provides citizens with a clearer understanding of what is at stake when the judiciary is undermined by the powerful and by the kind of populism we see here and elsewhere around the world. And Freedom Under Law and the department are also very grateful to the Millenium Trust for understanding what we are trying to do and for their support of this project in particular and democracy building work in general. Before I hand over to Herman to introduce Dario, just to say that the way in which we're going to run the evening is Dario will speak for about half an hour. He'll be a disciplined lawyer, I'm sure. And we will open it up to your questions and comments. And please feel free to think about those while you're listening carefully to him. And that will stand between you and a drink and a canapé. But feel free to have as many questions as you like. There are many people who, particularly legal journalists, who've wanted to be here tonight, but for various reasons and because they're based in Johannesburg, can't be here this evening. But we are recording this lecture, and it will be made widely available, both on our websites and also in the media. So there will be an opportunity for those of you, for people who have missed it, to actually listen to it again, but also to look back on it. So before I bang on for too long, I'm going to hand over to Herman to introduce Dario. Thank you.
Good evening, everyone, and welcome on behalf of the Department of Journalism at Stellenbosch University as well. It is my pleasure and honor to welcome and introduce Dario Milo. Dario is a media lawyer at Webber Wentzel Attorneys, where he has practiced for 20 years. He's an adjunct professor of media law at Wits University, and he has also guest lectured in our department earlier this year, and hopefully will do so again in future. Dario has acted in many of the significant media freedom cases in South African law, including in areas such as defamation, surveillance, open justice, and access to information. He is a member of the high-level panel of legal experts on media freedom chaired by Lord David Neuberger. He is also a global freedom of expression expert at Columbia University, and he was an expert advisor to the European Commission in relation to its anti-SLAPP proposals. Which brings us to the subject of today's lecture. Tonight's lecture is Strategic Lawsuits Against Public Participation, if you wondered what SLAPP stands for, the role of the judiciary, the media, and parliament in slapping back. Welcome, Dario.
Thank you. Thanks so much. Good evening, everyone. It's a great honor to be here today. Thank you so much for those kind words, Herman and Judith. And it's also a great privilege to be amongst Judge Krichler, who both before, during, and after his tenure at the Constitutional Court has been an unparalleled asset to our country. So I recognize Judge Krichler and, of course, others in the audience, such as some of my clients are here, and some of the students who I lectured a bit earlier this year. So good to be back in Stellenbosch, and thank you for the invitation. The topic I've chosen to deal with today is SLAPPS, Strategic Litigational Lawsuits Against Public Participation. And I want to illustrate why SLAPPS are a problem for democracy. I think it's pretty obvious, but I'd like to talk a bit about that. I want to tell you about how South African courts have grappled with SLAPPS and how in the recent years they've developed a creative, compelling, but ultimately only a partial solution to the SLAPP problem through the common law. And there are three cases in particular that are instructive in recent years that I'd like to talk about in relation to abuse of process. I call them the 3 M's: mineral sands, Morn, and Mazzetti, and we'll get to all of them in due course. I want to illustrate briefly the global context and highlight that we are at what I think is an inflection point for various reasons. SLAPPS, the momentum to enact anti-SLAPP legislation is growing around the world. And I want to end by challenging our lawmakers, our parliamentarians, and the media to deal decisively with SLAPPS in their specific spheres of influence. For journalists and free speech NGOs, I want to argue that a coalition against SLAPPS is necessary and critical. And this includes, and this touches on what this partnership is all about, it includes quality journalism in investigating and reporting on SLAPPS, as well as debunking the disinformation campaigns that often accompany SLAPPS. And I'll get to that too. But perhaps starting from the beginning, what are SLAPPS? The name and even the acronym, for once, are good descriptions. Strategic litigation against public participation. So it's strategic, it's orchestrated, it's to stop people participating in the public domain, in the public realm, in a critical way. And so it's an area of law that's weaponized, often by the rich and powerful, to litigate against those who, through public commentary or activism, have become thorns in their sides. Critics, journalists, human rights defenders, environmentalists, other activists, truth tellers. The legal process is what matters to slappers, not the outcome. They're not interested in the outcome. They're only interested in weaponizing the process. The process is abused for their ulterior purposes. I think Judge Goliath in the Western Cape High Court summarized this phenomenon well in the first major SLAPP case in South Africa. And this is the first of the M's that I want to talk about, the mineral sands case. She says the following: the signature elements of SLAPP cases is the use of the legal system disguised as an ordinary civil claim designed to discourage others from speaking. And she goes on to say, in essence, I'm skipping a bit, SLAPPs are designed to turn the justice system into a weapon to intimidate people who are exercising their constitutional rights, restrain public interest in advocacy and activism, and convert matters of public interest into technical private law disputes. And I suppose only in South Africa would the first major case on SLAPPs be adjudicated by a judge by the name Goliath, because these are often David and Goliath battles. So to summarize, the strategy is a simple one. It's a strategy which you would all be very familiar with, those in the journalism profession. It is to financially and emotionally exhaust the target of the lawsuit and to send a signal to that person and others who are similarly situated that don't you dare attempt to speak truth to power. It's a classic illustration of the chilling effect on freedom of expression. And without freedom of expression, as we know, the lights go out on our democracy, and we can't even blame ESCOM for that. I need not regale you with the endless, beautiful poetry from our courts on freedom of expression and media freedom. But I do find special resonance on this topic in the comments of Judge Sachs in the Laugh It Off case, which you might remember was a case about the T-shirt on the right of the slide, Black Labour, White Guilt, the parody which commented on South African breweries. And Judge Sachs says this: of more significance from a constitutional point of view is the manner in which even the threat of litigation can stifle legitimate debate. Large businesses have special access to wealth, the media, and government. The tarnishment theory of trademark dilution, which you needn't know much about and don't need to know anything about, but that could chill public discourse because trademark law could be used to encourage prospective speakers to engage in undue self-censorship. That's the chilling effect. To avoid the negative consequence of speaking, being involved in a ruinous lawsuit. The cost could be inordinately high for an individual faced with a lawsuit aimed at silencing a critic, not only in terms of general litigation expenses, but also through the disruption of families and emotional upheaval. Such protracted vexation can have the effect of discouraging even the hardiest of souls from exercising their free speech rights. And Judge Sachs could easily have been speaking about the deleterious impact of SLAPPS on free speech and our democracy. So I hope I've persuaded you that SLAPPS undermine democracy and they're a problem for our democracy. But if the discussion so far hasn't persuaded you, I want to talk about a few cases and case studies which hopefully will. And I start with a classic one, which I've told a number of times before, but which deserves and warrants a retelling in this context. It's a story about a president who sues his critics in the media. Of course, you might remember that between 2006 and 2010, Jacob Zuma, who became president in 2009, sued the media and other critics for defamation in 15 cases. And defamation is the go-to law for slappers. I mean, slappers use all kinds of laws that they can get their hands on, but defamation is still widely regarded as the main law because it is about speech and it's about stifling speech. So in these 15 cases, Zuma sued 8 newspapers, a radio station, 2 cartoonists, a columnist, op-ed writers, journalists, an artist, and an art gallery. And you see some of his claims on the slide and one of the summonses, one of the 15 summonses. And at one stage, the total claim in these cases was around 65 million rand. And when one considers that the Supreme Court of Appeal has regarded a sum of 500,000, 500,000 as excessive in a defamation context, you can see how disproportionate those kinds of claims were. But our thin-skinned then president was valuing his reputation very highly indeed. What it meant for the media defendants in those cases is that they would face potentially years of litigation, massive legal costs, emotional pain and suffering, and diversion of resources just to defend themselves. The claims in most cases were actually not even about factual statements, which Zuma was complaining about. Mostly they were about opinions or satire or even a joke or two. And one of the opinion pieces is up there by William Gumede, who wrote a piece criticizing Zuma's culture defense in his rape trial, of which he was, of course, acquitted. And these double-digit summonses for 7-figure claims were clearly, in my view, lawsuits designed to intimidate the media. Zuma left, as it happens, the defamation claims hanging over the heads of the media for years. And his strategy seemed to me to be to silence his critics and chill speech while he waged his political campaign to unseat then President Thabo Mbeki. So I believe he never cared about getting his day in court, using process and not caring about the outcome. And the strategy was going well, but the target of 3 of these lawsuits was Jonathan Zapiro. And because he had the luxury of being an award-winning cartoonist, a household name, whose publications were willing to fund him, Zapiro was able to double down, as he did in these cartoons, for example, challenging Zuma to articulate what reputation specifically he was suing over. Was it his reputation as a disgraced chauvinistic demagogue who can't control his sexual urges and who thinks a shower prevents AIDS? And calling him his publicist. And then, backed by his newspaper, who funded his legal fees, Zapiro adopted a proactive strategy to take on Zuma and to call his bluff in 2012, selecting one of the cases as a test case and dragging the reluctant plaintiff president to court kicking and screaming. I was privileged to represent Zapiro and the Sunday Times in the case. And of course, it concerned the Rape of Justice cartoon. And you see there an extract from Zuma's summons. In parallel, the context of the cartoon was that in 2008, as you'll remember, Zuma and his allies waged a political campaign to ensure that the corruption charges against him were never brought. And in parallel, his legal team embarked on the now well-known Stalingrad strategy, saying in court, and it's amazing to remember that this was actually expressly said in court by Zuma's then counsel, that they were going to adopt that strategy and fight the charges against Zuma. I'm just going to pause while we turn that off. Thank you. Zuma's counsel said in court that they were going to fight the charges against Zuma like the Battle of Stalingrad, burning house to house. And of course, we all know that political and legal strategy worked, because it was only 2 years ago, in 2021, 13 years after Zapiro's cartoon about the rape of justice, that Zuma appeared in court pleading not guilty to charges of corruption. And that case itself has been progressing at a snail's pace and has led to another SLAPP lawsuit by Zuma, which I'll come to shortly. So Zapiro's cartoon was classic fair comment, as hopefully the students that I saw a few months ago will remember. Some of you are nodding, which I'm pleased about. Because what Zapiro was commenting on is the public pronouncements by Zuma's allies that there would be blood on the streets if there were corruption charges against Zuma, that the judges of the Constitutional Court were counter-revolutionaries. But once he was forced to litigate his own case, Zuma retreated, dropping the case, tendering costs of the Sunday Times and Zapiro. There was no way left to hide, and he knew he would likely face grueling cross-examination at the hands of Wim Trengove, and ultimately lose the case. And Zapiro was able to publish his own David and Goliath cartoon in victory. This anti-SLAPP victory, of course, though, was met the very next day with spin from Zuma's team, with his spokesman, Mac Maharaj, spinning and saying in the most tortured variety of logic on offer that this was done. Zuma had withdrawn the claim in the interests of freedom of expression, because he wanted to avoid setting a legal precedent, because he would win, so he said, that may have the effect of limiting the public exercise of free speech, with the unforeseen consequence that it may have on the public and citizens and the media. And a PR campaign, an orchestrated PR campaign, whether via government, politicians, or corporations, is another feature that I want to emphasize of a typical well-resourced SLAPP case. A campaign of disinformation is often used in parallel with the legal strategy, to buttress the legal strategy and to further intimidate the media or the target of the SLAPP. Now, the Zuma-Zapiro case was litigated over a decade ago, and while SLAPPs were known in America, Canada and the USA largely, we in South Africa and most other countries in the world lacked the terminology, the legal tools to argue that these were in fact SLAPP cases. In my opinion, if a SLAPP doctrine was around at the time, these would have been classic examples of SLAPPs. But fast forward 17 years, and 17 years after Zuma instituted his first defamation case, our law has now developed to the degree that we now get this kind of headline. This year, Zuma trounced how a former president's attempted SLAPP was slapped down. And this is the second of the 3M cases that I want to come to. I want to highlight the case involving Karen Moore, who of course also is significantly, and this is one of the reasons that she's a thorn in Zuma's side, the only journalist who was on the beat at the time of Zuma's corruption charge, one of the few journalists who was on the beat at the time of his original corruption charges, who is still actively covering his corruption case as it now is and as it goes on. And so we come full circle with Zuma and his weaponizing of the law, having burnt his fingers, trying to slap using defamation law all those years ago. The now former president tries out a new playbook against the media and against his own prosecutor, incidentally, Billy Downer. First lodging a criminal complaint with the NPA, then getting the Nolly prosecute certificate, and then embarking on a private prosecution of Karen Moore and Billy Downer, although I'm focusing on Karen Moore in her capacity as a journalist, a legal journalist. And here is what we see as the culmination of that strategy of embarking on a private prosecution. The leading journalist covering his trial for corruption and the prosecutor in the dock defending themselves as accused number one and accused number two. Now, once you know the facts of the case, I would suggest that even a first-year law student or journalism student would know that the prosecution was hopeless, the merits of the prosecution. It was all based on a letter that Zuma's doctor had given him and which he had himself attached to a court application for postponement, and that Billy Downer had also put in his affidavit agreeing to the postponement on one of the days of the criminal trial. Moore got access to the affidavit the way legal journalists always get access to court papers. She asked one of the parties, and in this case, one of the prosecutors, who gave it to her. She did what legal journalists do every single day of their working lives. Yet Zuma argued that this conduct, reporting on a public affidavit, his own affidavit, which contained an annexure which was public, he argued that that conduct was so egregious it warranted criminal prosecution and potential imprisonment. He dusted off a section of the National Prosecuting Authority Act, which says that documents in the possession of the prosecuting authority cannot be disclosed without the national director's permission. But this section obviously can't apply to a court document. So it's no surprise that, among other bases, the court in Pietermaritzburg set the criminal summons aside on the basis that the merits were clearly bad. Because what Zuma had not done, and which would have at least given him some hope of a case, is he hadn't asked the court to keep that letter confidential. And in fact, when you looked at the letter, it's obvious why he didn't, because the letter doesn't disclose his medical condition. It simply says that he's receiving treatment after an emergency procedure. It's hardly confidential, hardly private information, and hardly causes him an injury, which would have been necessary for him to show that he had the ability to privately prosecute. But happily, the court didn't just stop at the technicalities. It didn't say only, you can't sue because you didn't get a nulli prosecute certificate against Moore, which, by the way, he didn't. He had one against Downer, but not against Moore. It didn't only say your merits are hopeless. The court went on to do what we now expect courts to do in the post-Goliath mineral sands world, which was incidentally confirmed by the Constitutional Court. The court called this out as a SLAPP. And this is what the full court said, that Zuma's private prosecution has all the elements of a SLAPP. I'm skipping again to the bottom for time reasons. If one accepts Moor's submissions, she has demonstrated that Zuma's private prosecution has been instituted for the sole purpose of silencing her and not to vindicate any right on his part. And that was sourced in the submissions made by 3 media organizations, the Campaign for Free Expression, SANIF, and Media Monitoring Group, who intervened in the case and made submissions to the court. So there was what I'm going to come back to, a coalition of media organizations supporting the journalist who was attacked in that way. And not just in that way, because once again, there was the disinformation campaign, and further than that, there was assaults on Twitter and on social media against Karen Moore. And these are just a selection of those that she brought to the attention of the court by the Jacob Zuma Foundation, by Zuma's daughter, who tweeted, "You look good in orange," and a picture of Karen Moore in that guise, and of course far more vitriolic comments by anonymous members of the public who are supporters of Karen Moore. And the court again takes that into account in reaching its conclusion that this was an abuse of process. And happily, our friend Zapira was able to comment in his own way. And I see that he thinks, I think with some justification, that SLAPPS stands for Stalingrad Liar, Abused Press and Prosecutor. Now, all of that was made possible, as I say, because the Constitutional Court had accepted Goliath's ruling, which is not a model of clarity in many respects. But when it reached the Constitutional Court, the court said, we accept that there is an anti-SLAPP defense in our law flowing from the doctrine of abuse of process. This was a case about the mining activities of a multinational. Again, classic kind of SLAPP plaintiff. A multinational mining corporation taking on its environmental critics. And the critics were 3 environmental attorneys, activists in the space who, in the case of the attorneys, for instance, had given a talk at UCT summer school and made comments about the mining company, alleging that it was conducting prospecting activities in unlawful manner. And the other activists had, for example, written e-books, appeared on radio stations, and made similar comments criticizing the activities of the mining company. Judge Majid for the Constitutional Court accepted the defense, because it was a case that went on the technicality, what lawyers call an exception, which was taken to a defense that the defendants put up. The judge accepted that it was a proper defense to argue that this was a SLAPP in appropriate circumstances. And importantly, didn't say this particular case is a SLAPP, because that's for the trial court to determine in due course. But the court says the common law doctrine of abuse can accommodate the SLAPP suit. And the defense ensures that courts can protect their own integrity. So the Constitutional Court located this in the context of protecting the integrity of the court, guarding its own processes and preventing them from being, as the judge says, abused for odious ulterior purposes. And that finally brings me, in terms of South African developments, to the third M in the series, which is the Mazetti Amabungane case, and Mazetti being one of the companies in the Motti group. And we have here the Amabungane team who worked on the case with us quite relentlessly in the last few weeks. Because picture the scene. It's 8:30 p.m. on a Thursday night. You're having a glass of wine after a long day at the legal office. A WhatsApp alerts you to a court order that has appeared in your inbox and just been emailed to you. And the court order is one granted ex parte. That is, for the non-lawyers here, without any hearing of your client. The other side doesn't get an opportunity to be heard. The journalists in this case hadn't had an opportunity to argue their side of the story at all before the court had given its decision. And it required that the journalists must, within 48 hours, so by Saturday afternoon, because it being Thursday early evening, must within 48 hours return documents leaked to them by their confidential sources and on which they had been publishing stories of public interest for the past few weeks. More than that, the court order granted ex parte interdicts the journalists from publishing any further stories based on the documents until a return day set for 4 months' time, October this year. This is exactly what happened in democratic South Africa a few weeks ago to Amabungane in June this year. And it followed a series of articles they have published, which they've termed the Motti Files. The court order, which was obtained by Mazzetti and Ametti, two of the Motti Group's companies, undermined 4 cardinal principles of our law and our media law. And the first is obviously the principle of audi alteram partem, let the other side be heard, which is essential to the legitimacy of adjudication itself. Except for very exceptional cases, and as a student you learn it's the case where a plane is about to board with the ex-husband taking the child overseas without the permission of the ex-wife, that is where you can ex parte get an order and stop the ex-husband from boarding the flight. That's the kind of thing that ex partes are for. But hearing the other side is a critical principle of our law. It also undermined 3 critical principles of media law and fundamental principles of media law. It compelled Amabungane to reveal its sources effectively by revealing the documents. And in fact, the order said they had to, for instance, return documents that they may have obtained from the former employee of the Motti Group, who they claimed had stolen the documents. Secondly, it sought to argue that Amabungane's continued possession was the crime of theft, and that was, of course, something that implicates all leaked documents, including all the journalists who were leaked the Gupta documents many years ago, a couple of years ago. And thirdly, it enforced a prior restraint, a gagging order against the publication on the basis of the leaked documents. So Amabungane had to act quickly to reverse this travesty of justice, and it went to court before the 48-hour deadline, which was the first step, to get that varied, and that was successful. Secondly, it then urgently applied to court to reconsider the order, because in our procedural rules there is a provision allowing you to ask the court to reconsider an order granted ex parte. And that was heard by the Deputy Judge President in Johannesburg, Judge Sutherland. And he vindicated Amabungane on all of those 4 principles that I've spoken about, the 4 cardinal principles breached by the court order that was obtained ex parte. And one must criticize not just the applicants, but also, I'm afraid, the judge that granted that order in an ex parte setting. So Judge Sutherland said this was an egregious example of an abuse of the ex parte procedure. He said contraband information in the hands of a journalist is not in the category of, for example, possessing uncut diamonds, which was the example he gave. On the contrary, there's overwhelming support for such activity being a positive and necessary good for society. He said the resistance to disgorgement of information on the ground of protecting a source is functional and not optional to the work process of investigative journalism and not mala fide. And he said a South African court shall not shut the mouth of the media unless the fact-specific circumstances convincingly demonstrate that the public interest is not served, and that is likely to be rare. And that's the debunking of the prior restraint point. And again, not surprising in the context of those findings that Judge Sutherland found that the applicants should be mulcted in punitive costs. And now, of course, that was widely welcomed by the media and for all those who believe in media freedom. And what Sam Soul wrote about it in the audience, which I thought was particularly instructive, is this saga has demonstrated that our courts are vulnerable to blitzkrieg offenses, not just Stalingrad defenses. And I think that's a good summary of what Amabungane went through. But I'm afraid it's not over, because just a few days ago, the group, on the last day of the deadline, applied directly to the Constitutional Court for leave to appeal the judgment, and we'll have to wait and see if the Constitutional Court takes the case. Once again, well, in fact, before I get there, although Judge Sutherland stopped short of calling this a slap, it was argued by the media amici who intervened in the case on the following basis: the Holland Mutter order in this matter, coupled with the persistence of the litigation and the counter-application, which we can talk about during questions if we need to, collectively amount to a weaponization of our courts and pose serious threats to media freedom. And that is, of course, quintessentially what SLAPPS do. And essentially, by finding that this was an abuse of process, an egregious abuse of process, not least in the ex parte nature of it, Judge Sutherland has effectively, I would argue, found that this is another example of a SLAPP case in that particular context. Once again, the PR campaign was ramped up both before, during, and after the court proceeding, and it is of some disappointment, and Amba Bongani might want to talk a bit about this during the questions, that even some colleagues in the media field didn't give Amba Bongani the right of reply when the CEO of the Moti Group made critical statements about them in the context of these orders. And that's why I reflect at the end on the role of the media generally in forming a coalition to fight SLAPPS. So I want to zoom back now against those detailed developments in South Africa, the 3 M's, which have been important developments just in the last 2 years in our jurisprudence. I want to zoom back briefly to look at the global context. And before I get into what other countries do, I want to implore whoever it is who has the capacity and the resources out there, whichever organization can, or perhaps a number of organizations, to embark on empirical research on SLAPPS in South Africa, because that is critical. It's critical tools for lawyers and for activists. Lawyers in arguing cases before courts and for making law reform proposals. And we have some studies, for example, this study from in 2020, on the global south, not on South Africa specifically, but which finds, for example, that 66 of the 75 cases were defamation. But it's absolutely critical that we are armed with empirical research as well as these important case studies. And we've seen that, for example, in the context of the European developments. There's quite a lot of EU research on the prevalence of SLAPPS. This research, for example, from 2022 shows the graph on the right how SLAPPS have increased since 2010. If you look at 2010 at the bottom left to 2021, the top right, the increase in the amounts of SLAPPS recorded in Europe. And on the left, it shows that the status of the defendants still largely in Europe, journalists and media outlets. And in the United Kingdom, just last year, the government invited evidence to be submitted on SLAPPS and concluded by saying that when it heard this evidence, a lot of it was harrowing. It referred to the personal and professional toll of these claims against journalists and the chilling effect, and concluded that is why we are moving decisively to stamp out SLAPPS. So a call for more empirical research. And the product of this, the momentum of all this research and thinking around SLAPPS around the world has been in Europe, Daphne's Law, which is a draft directive developed by the European Commission and which is winding its way through Parliament, named after Daphne Galizia, who was a top investigative journalist in Malta and who was assassinated in 2017 by a car bomb, facing 40 civil defamation lawsuits and 5 criminal defamation lawsuits at the time of her death. We've seen in the UK just 2 weeks ago the introduction of draft legislation that would regulate SLAPPS where economic crimes like corruption are being reported on, following that call for evidence that I spoke about. The Solicitors Regulatory Authority has done something very interesting by issuing guidance to solicitors to discourage them from taking on cases and clients which could be regarded as SLAPPS. Even in the USA, which has had SLAPP laws for many years, there's a move towards the adoption by those states who don't have laws and by the revisiting by those who do of a uniform law on SLAPPS. And even in regional court judgments, like in the European Court of Human Rights and the Inter-American Court, there's increasing reference to the phenomenon of SLAPPS. In addition to all of that, we have 3 provinces in Canada and 32 states in America, as well as the District of Columbia, who have anti-SLAPP laws. It's only the red in that map, the red states, I'm not going to say the Republican states, but the red states who don't have laws. The reason there's different colors is this particular study has classed some of those laws as excellent, some as good, and some as sort of okay. But 2/3 of the states in America have anti-SLAPP laws. So what is fantastic about the common law is that it gives us tools, and the common law developments in the 3M cases, mineral sands, Morn, Mazzetti, is it gives us immediate common law tools to respond to SLAPPS if there's immediate litigation. But the gold standard is not common law development. The gold standard in this area must be legislation. And I think, therefore, that what we need to start thinking about and focusing our energies on is developing legislation to deal with SLAPPS at this inflection point where so many countries around the world are looking at this. I think that kind of legislation needs to have at least three things: early dismissal of a potential SLAPP suit, and that works extremely well in America and in Canada, right, where there is a very limited discovery process, and the courts can look at something early on, within 60 days usually of a claim being instituted, and decide whether this should go ahead or not. And if the media company, if that's the defendant, loses, they don't pay costs, and if they win, they get all their costs on a full indemnity basis. So that's the third point. And also I think there should be a reverse onus, that once, and many of the laws do this, once the defendant is able to show that this was an act of public participation in the public interest, the onus should be on the plaintiff to show why they should be allowed to proceed with the case, why they are likely to succeed at trial. So I think there's an important role to be played by Parliament. I think there's a critically important role to be played by the media, because to my mind, it's been gratifying to see statements by media organizations and NGOs, for example, in the Morn and the Amabungane matters, not just locally but internationally, statements of support. Importantly, intervention as amici in these cases. The Campaign for Free Expression, Media Monitoring, SANEF played roles in both the Morn and the Amabungane case. And then, very importantly, I think tackling disinformation. So there where I think it links to the project that's being developed here by Freedom Under Law and the Journalism School, is to encourage quality journalism, analytical journalism, not just in terms of immersing yourself in the legal documents so that you can report accurately on the case, but also being able to interrogate so that when a slapper appears on your show and gives an interview, you are able to call them out for the disinformation that they're spewing, and not just reading the next question on your list and letting the slapper rattle on, because we do see a lot of that. I want to end with one of my favorite quotes, which is from Judge Moseneke. And it's not from one of his judgments, it's from a speech he gave at the National Press Club in 2015. He said, we ask, in addressing the media, we ask that in carrying out your responsibilities, you worship at the altar of accuracy. And I think that has always been something that I think should be tattooed on the arm of a journalist, perhaps along with the word Bagoshi, which is what Judge Sutherland said should be tattooed. It's named after a famous media freedom case in South Africa. I hope I've made good on my promise to illustrate why the issue of addressing SLAPPS is a burning one for our democracy. SLAPPS operate, of course, within a broader legal context, and I should acknowledge two other developments which have been very positive in South Africa and which will help fight SLAPPS. The first is the companion judgment to mineral sands. In another judgment, the same parties, another issue, the Constitutional Court held that trading corporations should generally not be awarded damages in defamation matters on matters of public interest. It's not an absolute rule, but generally they should not get damages in public interest matters. And that's an important principle which deters corporates potentially from bringing defamation cases. Secondly, there's a bill winding its way through our Parliament which will abolish criminal defamation law. And that's another very important development and a welcome development, along with the anti-SLAPP defense that has been recognized by the Constitutional Court. But if the international experience teaches us anything, it's that law is only one piece of this anti-SLAPP puzzle. It takes a village to fight a SLAPP, and I invite all of you in your different capacities to take up residency in that village. I thank you.
Thank you very much, Dario. I think you've just again demonstrated why you are such an asset to the media in South Africa and to the public, because I mean these victories for media freedom are victories for the public in general. So thank you very much for your insightful talk. We now have some time for Q&A. I think we'll take 3 questions at a time, if that's okay, and then hand over to Dario. Wake up those of you who are So we'll take a few questions at a time. So, floor is open. Students know that they should be asking questions. Probably just polite. Yes?
Hi. Dario, can I ask, what's your take on the blowback for courts and for the judicial system of these cases, coming through the courts? I mean, we know that there's a lot of bad actors out there who are sort of bringing cases that seem to be hopeless cases, whose sole goal sometimes seems to be just so that they can lose and then say, you see, the courts are biased. I don't think there's much that the courts can do except hear these cases, but do you think that there's blowback, that there's harm that comes when the courts are weaponized? Particularly harm to the courts themselves and to the judicial system and the faith in the courts.
Thank you. Can I also ask you to introduce yourself?
Sorry, Susan Comrie from Amabungani.
Could I tie in with that?
Sure.
And it's a simple question. I think everybody can hear it. Dario was speaking to journalists here and rightly emphasizing the journalistic aspect of the problem. But fundamentally, it's a lawyer's problem. Fundamentally, this lady has scored the fundamental point that it is crooked lawyers who are making SLAPP possible, and SLAPP is just a manifestation of a wider issue, the whole stolen ground defense issue of crooked lawyers allowing their profession to be used to abuse the law. And that's the real problem. And that's not going to be addressed by legislation unless you address the crooked lawyers in the issue. And I would suggest that a very salutary remedy should be, and I disagree with this young lady, I happen to be a lawyer, I happen to have been in the courts for some time. The courts certainly have every tool in the business to deal with crooked practitioners. Strike them off the road. Cut off their own personal lights and water. Using the tools that they were given for abuse of the law. SLAPP can be dealt with, but it must be dealt with by tough-minded judges. Thanks.
There was the hand. Did you? Yes, go ahead.
Thank you, Dario. This is excellent. My name is Henk, and I want to ask you or challenge you about the scope of the phenomena of weaponizing the law, because most SLAPPS in South Africa are against the village, the rural village. So weekly, on a Friday afternoon, the crooked lawyer goes to the crooked magistrate on behalf of the crooked chief to ban the meeting in the village on Saturday or Sunday, or to ban the funeral because the deceased did not pay or did not like or did not to be buried on their own land. So that's where court and court processes are also abused, not only the high-level cases. And it comes with such viciousness because it's the blitzkrieg and the Stellenbosch. Now Sam is sitting with what legal costs of ongoing, because it's now constitutional. But the poor victim of the SLAPPS in the village is now ruined because it's now, the cost orders are just building up. And the magistrate, of course, plays along with it. So that's the part of the conflict. Now you ask some people and they say, oh, we've got that 1957 Act about, I don't know, what, delinquent litigant or what, vexatious litigant. It's useless. You tell a magistrate about that, he's not going to hear. To appeal that to another court to get to this good judge, that the good judge in the High Court is impossible. Who's going to fund it? Now, coming from the journalist side, the nature of the profession has just changed completely. Those cases and rural doesn't make the papers or the social media at all. 20 million people in South Africa remains under the radar of attention. I don't know whether that's happening in Europe and with black people in the US of A. I suspect that when it comes to, you know, this redlining of court orders against evicting people, the same thing may happen there. But that's where we've also got to look at and where we've got to put our attention. And how do we change the journalism to get back to where it matters?
Thank you. Shall we take one more question?
Well, Dario, I mean, I suppose it dovetails with what Judge Crickler was talking about. I mean, you mentioned something about guidance in the UK for against practitioners who use this, and so be interested to know what exactly that entails. You know, if one is talking about legal ethics. Thanks.
Thank you. I think some common themes to many of the questions, but I'm firstly very grateful that Judge Crickler has answered Susan's very difficult question for me. But I do think that what we need to, and I must say I did consider it in some of these recent cases that I've been involved in. I think the time must come when we deploy the ability to get costs from the attorneys involved, de bonus propria costs as we call them, far more than we do at present. You know, we've seen a very long line now of cases where the public protector, for example, has been ordered because of her reckless and egregious litigating conduct to pay costs out of her own pocket, not the office of the public protector. And I think that in these SLAPP cases, where you can show that the legal practitioners also must have been involved in the advice they gave and in the prosecution of the matter, you know, that there is scope for a de bonus propria disincentive to those lawyers. You know, particularly when one, I mean, in the ex parte nature, for example, of the Amabungane case attracted a scathing commentary by Judge Sutherland, not just in the written judgment, even more so in his challenge to Mazzetti's lawyers in the case. And it seems to me that, you know, from that perspective, there are those kind of tools that we have at our disposal which we should be utilizing more. The second piece to that is the legal ethics side. I think just like the Solicitors Regulatory Authority in the UK has adopted this guidance on SLAPPS, you know, the LPC should be looking at something like that for South African attorneys and counsel. And Judith, to your question specifically, it's fairly abbreviated guidance, but it has some pretty practical things, because one of the, attending a conference in London on this last year, one of the constant complaints made by a number of media companies and community media is that they get these letters from lawyers, aggressive letters, which are marked private and confidential, not for publication. And the lawyers, there are threats, there's aggression, and it's on the basis of bogus merits. And the guidance makes clear that when your client comes to you with effectively asking you to be a PR spokesperson rather than a lawyer, but to use your letterhead to intimidate and to bully, that's the kind of case you shouldn't take on, and you can face regulatory scrutiny. So I think it's a start. It certainly needs far more muscle. We need something like that here, and that kind of guidance. And the Bar Council there, because they had a representative at this conference, is apparently looking at also rules around cross-examination of SLAPP victims. Just like there are ethical rules around cross-examination of victims of sexual crimes, there should also be cross-examination rules around and interventions by judges in relation to targets of SLAPPS. So there certainly is a piece here. Absolutely agree, for the legal profession generally, and I think Judge Crickler is absolutely spot on in responding to Susan's comment. Henk, I take your point. I mean, I think that there certainly needs to be far more publicity around those kinds of cases in the magistrates' court. And in terms of the legal response, the devil's going to be in the detail of how you define a SLAPP law, right, and what you extend it to. In England, for example, there's a lot of criticism that their current draft law only applies to reports about economic crimes. It doesn't go beyond that. So we have to make sure our law is expansive. We need to learn from the quite rich jurisprudence, for example, in Canada, where there is, I think, quite important law, and I know the Constitutional Court also was quite attracted to the Canadian model, around how you define public interest, how you then shift the onus, and when you allow cases through the screening process. So we need to develop that kind of draft law here, and I don't think we must wait for parliamentarians. We need to be activists about it. We need to research, we need to do the empirical research, we need to do the legal research, we need to do the drafting, we need to lobby, and we need to get that kind of law passed, in my view. I think I've pretty much dealt with most of the questions. Thank you.
Thank you. Shall I take another round?
Yeah, I'm happy to.
Questions? Okay, thank you.
Maybe it's because I'm a lawyer, or at least a lawyer who's with Dario, not nearly as interesting as Dario. Your answer just brought me to the question that I was wondering, which is a legal one, not a journalistic one, but how would you need to define a SLAPP court case so that it can be preemptively recognized? I mean, your very interesting talk, which gave a very interesting overview and some details about the development of the whole thing, doesn't end with a definition. I assume you have one. Clearly, there's the screening definition that's required, and then also sanctions, the ones that Crickler were mentioning and what you were just talking about, the cost issue, if it should get to that. But obviously, it seems like the aim of legislation would be to stop it before it goes through the process. So I'd be interested to hear what your suggestion is, because you just mentioned also you'd have to define public interest. I mean, it becomes a very complicated beast, right? Does that not then also place a big bottleneck? Is there discretion for a case to be referred for screening? I mean, I know these are all theoretical questions currently, clearly you've grappled with them, but I'd be interested to know how you envision that working, where you think we should head when we start investigating this.
Thank you. Thanks for that question.
Thank you, Herman. I would just be really interested to know whether you think the absence of regulation around SLAPP at the moment might also undermine whistleblowing in South Africa, because one wonders if there's a relationship between the two. So many potential whistleblowers just might be really put off by possible defamation cases or any other sort of legal slap that they may get for wanting to spill beans. And I suppose the other side of the coin is, would pieces of legislation inadvertently, I suppose, extend some protection to whistleblowers? Thanks.
My name is Daniel. I'm one of the journalism honors students here at Stellenbosch. So my question is related to the social media and PR campaigns that kind of accompany these SLAPP cases. How do you deal with those in terms of a legal framework, but also, I guess, a more regulatory framework in terms of like independent regulatory bodies, or are those something that can be dealt with legally?
Thanks, Daniel. Any other questions? Oh, yeah.
Sorry, I'm Sam Soul from Amabungane. It's more a question to Professor Wasserman than to Dario. But it goes to the point that Dario is making about the environment in which we're working and the lack of kind of collegial standards, because in my experience, the judiciary has been tremendously supportive of the media and media freedom, etc. And I think we, at least in Amabungani, I hope we have risen to the challenge of that constitutional responsibility. We have met the standard that deserves the support that we've got from the courts. When I look at the broader media environment, I worry that we're not able to make that case, that actually we're performing a constitutional duty that deserves support and protection of the courts. I don't see the broader media actually taking on that reality, that, will the society and through them the courts decide we're actually worthy of protection, that we're doing our job properly.
Okay, let's hand over to Dario. Dario, you can ask my question as well if you want.
I'll leave that one for you. Great question, Peggy. I mean, you're right. I mean, the interesting thing, and that's why that map I put up of America has the different colors. In the 66% of the states where they all have SLAPP laws, some are good, some are bad, some are ugly, and then there are ones that don't have any SLAPP laws. And the difference is in how they define SLAPPS to trigger that early mechanism. There's no doubt there needs to be an early dismissal process. It's one of the problems with the Constitutional Court cases as it currently is, right? Is that, and not a criticism